over to Advocate Feroze Boda, who is the Director of Access HR Consulting. He will be performing the role of MC and facilitator this afternoon. And thank you to everybody for joining us. The slides will be shared afterwards, and welcome to put your questions in the chat. Please mute yourselves, and at the end of questions, you're also welcome to ask questions verbally. Thanks very much. Over to you, Feroze.
Thank you very much, Claire. Welcome, everybody, and a special welcome to our three guests. We're very thankful to Access for hosting this seminar on harassment. And we've got three very high-powered speakers from different parts of the world who I have no doubt are going to give you lots of food for thought. The first speaker is Makbool Javaid. He's a partner in the employment team at Simmons, Muirhead and Burton LLP in London, United Kingdom. He's widely regarded as a leading practitioner in the employment law field and related regulatory and investigative matters. Makbool has substantial experience advising public bodies and was formerly head of litigation services at the Commission for Racial Equality and has been involved in several high-profile cases in the appellate courts. He is described by the Legal 500 as a highly respected discrimination law practitioner and previously as business-minded, down-to-earth, and a good man to have on your side. The Chambers has stated that he runs a tight ship and employs a particularly intuitive understanding of discrimination cases. Makbool is the Managing Director of Access HR Consulting South Africa. He is well regarded in South Africa for offering practical and cost-effective solutions to HR and legal issues. Makbool will be addressing you very briefly on what Access does, and then he's going to give a presentation to highlight an international context to the Code on the Prevention of Violence and Harassment in the Workplace. This seminar comes hot on the heels of the introduction by the Department of Labor of the Code of Good Practice on the Prevention and Elimination of Harassment in the Workplace, which Professor John Grogan has recently described in an article as the Code of Good Manners. And Makbool will give you some international context to the code. The second speaker is George van der Merwe. George has a field of expertise is in all areas of employment law, as well as pension law and litigation. George was a founding member of SGB Attorneys in 2005. He's well respected and a recognized attorney in the fields of employment and pension law. George boasts both BLC and LLB degrees, as well as a master's degrees in law, and also a certificate in pension law. George has acted as a judge in the labor court and is a qualified mediator and arbitrator, and holds a certificate in conciliation, mediation, and arbitration cum laude. George is a regular speaker at employment law seminars and is an accredited assessor and moderator. Our third speaker will be Nic Preston. He's coming to you directly, he's beaming to you from Canada. It's quite early in the morning there. Nic is a dual qualified lawyer who enjoyed a successful partnership at one of South Africa's largest law firms before continuing his legal career in Canada. With a decade of devoted focus to the management side of labor and employment law, Nic provides pragmatic and cost-effective counsel to executives and HR professionals across a variety of sectors, including in the automotive, chemical, construction, education, healthcare, manufacturing, municipal steel, retail, tech, and transport industries. Nic continues to successfully advocate contentious litigation disputes across both unionized and non-unionized environments. George will be focusing more into the content of our recent code and giving you the ups and downs of it and the implications of it. And Nic will be concluding by giving you a perspective from his side of the world. I hope each speaker will have about 15 to 20 minutes, and I hope we'll have time for questions at the end. So I want to thank you all for joining us, and I'll hand over to Makbool to tell you a little bit about Access and then do his presentation. Thank you very much.
Well, thank you, Feroze, and good afternoon to you all. Good morning to Nic, who's in Canada. Well, it's a pleasure and an honor to be able to join you to talk about the code of practice which George will focus in on. I think as lawyers, traditionally in the past, our job was to advise in relation to technical legal issues. But increasingly, my view, based on my experience, is that as labor law lawyers, lawyers generally, our role is more as advisors to businesses and also advising in relation to the management of risk. And this really is the genesis for Access, which seeks to bring together best practice from all over the world and apply it in particular jurisdictions to learn the lessons of how the law is applied and developed in different parts of the world. And I practice in the UK. And we seek to advise, as I say, businesses in relation to areas of risk. And, you know, claims can be settled and agreements can be reached between parties, but reputations once damaged are very difficult to repair and can have catastrophic consequences. So I'm going to be direct with you today and say to you that this particular area that we're going to be looking at ranks as a high risk area, and businesses need to stand up and take notice and to engage in proactive measures and not wait for disaster to strike. Next slide. Now, if you're not persuaded by what I say there, then you just have to learn the lesson involving this individual. Now, you may not know who he is. His name is Chris Pincher. You will be aware that there is some political turmoil in the UK at the moment, with the Prime Minister having to step down. And the reasons why he's had to step down are complicated. But the straw that broke the camel's back was an incident involving this individual. This individual, Chris Pincher, was a junior minister in the Foreign Office, and in 2017 was the subject of a complaint of harassment, and that was dealt with not in the best way possible, and Chris Pincher survived. He remained in the Conservative Party, which is the ruling party, and was promoted by Boris Johnson as Prime Minister to become the Deputy Chief Whip. And unfortunately, Chris Pincher got involved in when the complaint was made, individuals at an event at the Carlton Club, and he resigned. The question thereafter was, did Boris Johnson as Prime Minister know about the previous complaints made against him? And despite that, he promoted him. At first, the Prime Minister denied he had any knowledge. And it wasn't until a senior civil servant went public to say that a complaint had been made that Downing Street and Boris Johnson in particular had to row backwards in an extreme hurry. The Prime Minister apologized and said he was aware and he was sorry that he had promoted him despite the complaint. That led to a series of events where his colleagues felt that they had had enough. They resigned and the government fell apart, all because of a way that a complaint of sexual harassment had been dealt with. So that is a salutary lesson that the mightiest of all can fall as a result of not heeding that lesson that I gave you at the outset, which is this is a high-risk area and that one has to be proactive in the way that harassment and discrimination issues are dealt with. Next slide. Actually, you may have noticed there was a quote there saying, "Pincher by name, Pincher by nature." This was an allegation made against Boris Johnson, and that's what he said, which gave the impression that he didn't take this issue seriously. Once again, underline the fact that this is a high-risk area. Now, what is the statutory framework? This will not come as a major surprise to you. The Equality Act 2010 sets out the types of harassment that are declared unlawful. There are three types: harassment related to a relevant protected characteristic, sexual harassment, and then less favorable treatment because you reject sexual harassment related to your sex or gender. Now, the first one, which is harassment related to relevant protected characteristic, is quite broad. It's not just about sexual harassment. It deals with any protected characteristic. And in the UK Equality Act, there are 9, such as race, age, religion, disability, similar to the kind of framework that you have in South Africa. So it's broadly outlawing harassment if it's linked to one of these 9 grounds. Next slide. Those of you who have looked at the code will recognize this formula. So I'm using sex as one of the protected characteristics. It could be race, religion, or disability. So the way that the lawmakers have set out the formula is that there has to be unwanted conduct related to that characteristic. As I say, it could be age, race, disability, or whatever. And that unwanted conduct has the purpose or effect of violating the worker's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for that worker. Please bear in mind the words purpose or effect. So as lawyers, we can sometimes complicate things, and Access, we believe that we should present law in a way that is comprehensible by those who have to apply it. So you have unwanted conduct, it's got to relate to a protected characteristic, and it has the purpose or effect of violating, creating an indemnity, as set out there. So please bear that in mind. Next. So the question is, what does unwanted mean? And the courts have indicated, and there's similar codes of practice in the UK, that the unwanted means, as one would expect, that it's unwelcome or uninvited. Important principles to note: it's not necessary for the individual, the victim, to express any objection. You don't have to show that there has been an express objection. For example, sometimes the perpetrator may argue, well, they were just trying to test the water. That doesn't work. Thirdly, it can be a single incident, because the common understanding of harassment is that it has to be repeated more than one. Courts have been very clear. It can be a single incident. It doesn't have to be more than that. Fourthly, there may be a context, there may be a history, in the sense that this may not be the first time that the individual has been subjected to harassment. That doesn't make any difference. You may accept treatment which is unacceptable, but then choose to stop. Fifthly, there may be a history of banter. You may exchange inappropriate language, or may seem to accept the harassment, commonly known as banter. But the courts have said that this should not indicate that harassment hasn't taken place, because sometimes individuals use that as a coping strategy to deal with inappropriate behavior. So remember those points. Next slide. So I said to you it was important for you to be aware of the fact that this has the... Now, what does purpose or effect mean? Because your code also uses the same formula. So in order to understand what purpose or effect is, we need to break it down. First of all, purpose. If the behavior on the face of it clearly amounts to harassment, so that there is use of inappropriate language, say sexually charged language or racially charged language, then clearly one can interpret that to mean that this was the purpose. In other words, it was obvious what was going on. However, most cases of harassment, it's not obvious. And so what the courts have devised is a way of ascertaining whether it is unlawful. And in order to do that, they look at the effect of it. Now, in order to understand the effect, there is what's known as a subjective objective test. First of all, how does the complainant how did the complainant perceive that behavior? So their subject assessment is important, their evidence. You then obviously look at the other circumstances, the health of the individual, mental health, mental capacity, previous experience of work environment, put all that into the mix. And finally, you look at whether, given all those facts, the way that the individual perceived it, the broader circumstances, the work environment, cultural norms, whether given all that, it was reasonable for that individual to regard that behavior as amounting to harassment. So it would depend on the circumstances when it isn't obvious. Now, I can illustrate that with a case which involved a manager referring to one of his junior employees as a young lady. Now, on the face of it, calling somebody young lady doesn't seem objectionable. However, the manager referred to the member of staff as young lady in formal meetings. She was one female out of a team of 10, and she was the only woman, and he kept referring to her as young lady. And the court ruled that this amounted to harassment because by not referring to her by name, but referring to her as young lady in that environment, had the effect of violating her dignity and creating an oppressive, intimidating work environment. It kind of gave the impression that she was immature, inexperienced, and therefore amounted to harassment. So what people may regard as innocent young lady amounted to harassment given the circumstances. Next slide. The second type of sexual harassment is the second type of harassment is sexual harassment, where it's quite clear that the unwanted conduct is of a sexual nature. It doesn't have to be sexually motivated, only sexual in nature. Next slide. And the example given there is where material of a sexual nature is displayed, such as a topless calendar, and this has been viewed by the courts as creating an offensive and intimidating work environment. There's no sexual motivation, but one of the individuals working in that environment feels that this was created this intimidating, hostile work environment. And so this is a second category. Next slide. So the third type is very straightforward. This is where someone is treated less favorably because of the harassment. Next slide. And illustrated, so a manager propositions one of his assistants, she rejects his advances, she's turned down for promotion, and she believes she would have got the job had it not been for her rejection of her boss's advances. They're quite clear. So you have the broad category, then you have sexual harassment where it's material of a sexual nature, and the third one where the harassment is rejected. So those are the broad categories. Next slide. Now, in the UK, you do have a defense. As you know, as an employer, you're vicariously liable for the acts of your employees carried during the course of employment. I won't go into what that actually means, but basically, so long as the employee is not acting on a frolic of their own, you're liable for whatever actions they take. There is a provision allowing you to escape liability if you can show that you've done everything possible to prevent harassment. And the statutory formula is that you took all reasonable steps to prevent harassment taking place. You would think that that gives you a way out of these cases. And it will not surprise you that the courts have taken a very restrictive view as regards to what amounts to reasonable steps to prevent harassment. Their view is that if it's interpreted too broadly as a defense, employers will escape liability, whereas as a matter of public policy, it is important to create work environments which are inclusive and where there is no harassment. So if employers in the UK, and very few have succeeded are to be able to run that defense, they have to show that they had comprehensive training in place, that it was done on a regular basis, it was consistent. So in short, there was a comprehensive program of action in place to eliminate that harassment taking place. If you can show that, you will have a defense to any claim. So I want to look at what it is that we can do, because it's not enough, as I said, as lawyers to tell you what the law is, but what we pride ourselves on Access is to give you the solutions. Next slide. Now, my submission to you is that you need to take action in reducing harassment complaints, and the way that you can do it is some of the solutions that Access is able to provide. So you need to have an effective, speedy resolution process. Unfortunately, my view is far too many businesses involved in relation to these issues do not have an effective or speedy resolution process. It's too complicated. It's like a court hearing taking place in your business. We cannot continue along these lines because it eats up resources and creates real complexities. And there is judicial authority to say that the approach that too many businesses are taking in South Africa is unnecessary. You can reduce the way that you deal with these matters and have a more speedy resolution. Comprehensive training program speaks for itself. For some businesses, we've created a mediation scheme whereby you can either have external mediators or you can train an internal group of individuals to engage in mediation. If you're able to mediate these matters, much better than having a grievance process which creates tension and anxiety for all concerned, uses up resources which are should be allocated to doing what the business should be doing and not trying to recreate a court in their own building. Having universal sanction mechanisms. The code talks about zero tolerance culture. That is important to create. Zero tolerance will be the mantra going forward. You need to have fit for purpose policy framework. Unfortunately, as I say, the policy framework is too complicated. The processes involved are far too detailed, where we need to have speedy, simple to follow processes that everyone understand. You can have anti-harassment campaigns, and you can have work champions. Somebody's asked a question which I'll deal with later. Next slide. So, what do alleged world leaders do in relation to harassment? You've got Facebook. They've got compulsory training for managers, an onboarding induction process where everybody has to go through training. They have an anonymous harassment line, specialist HR teams. Sometimes the HR teams are not equipped to deal with harassment issues because it requires a specific expertise. Therefore, you need a specialist team. They have a dating policy. Well, there is a joke, perhaps made in bad taste, that lots of people meet each other at work, and lots of marriages occur as a result of being at work. And sometimes it's said these are sexual harassment cases that have gone wrong, where it all turns out well and people have no problems. But in order to deal with that, Facebook have a dating policy where basically you can only ask someone out on a date if you work with a work colleague once, but it tries to regulate that. Also, a policy saying that if you witness harassment, then that means that you're complicit. And there is this bystander training that you can engage in. So you can see this is a vast array of measures that are taken. Next slide. Google, once again, have mandatory training, publish annual discrimination statistics, have an employee support program, not surprisingly have a supplier code of conduct, and have when it comes to promotions and appointments, they have a diverse, which is known as the Rooney Rule, familiar with. Once again, what do you take from this? You take from this proactivity. that you need to take action rather than sitting back and watching the disaster unfold. To drink limit at social events. We want people to have a good time. However, we want to be able to control the situation. The Chris Pincher incident happened. Wasn't a worker-related event, but he drank too much and then behaved inappropriately. And as I relayed to you earlier, and you may have read, it eventually led to the downfall of the most powerful individual in the UK political system. Next slide. Microsoft, similarly, look at that. They promise outcomes within 1 month. Does your business do that? Or does your business take 6 months, 8 months, while you're paying the individual, the complainant? It cannot work anymore going forward, given the squeeze that there is on budgets. We need to have more efficient processes. They have an employee advocacy team that deals with complaints on behalf of individuals. They also publish the statistics, and they also have a system whereby when it comes to penalties, that this requires sign off from senior people within the business. In order to avoid the Boris Johnson situation where you do not take the action which is required. Now I'm just finishing, slightly running over my allocated time. Next slide. One way of tackling the inappropriate behavior in the workplace is to have in place what's known as a traffic light system, where individuals are able to highlight that the conduct, say in a meeting, to say, well, look, this is a behavior which is amber, green, yellow, or red, in order to avoid confrontation. That may not be appropriate, but it's just a way of showing how you need to be innovative. So that's a very quick run through as to statutory framework in the UK. But as I say, the lessons to learn are that we have to go beyond the minutiae of the legal rules. We have to be proactive. We have to look at risk. We have to manage that risk. We have to convince the board of directors that these are high risk areas and that it is necessary to invest funds in carrying out some of the measures that I have set out. In answer to the question that was made, the young lady case, the individual was dismissed. Thank you very much. And if you have any questions, I can take them later. Thank you.
Thank you very much, Makbool. I think that the the buzzword that Makbool tells us is be proactive. And while we all know this is a high risk area, there you have it. The British government is rocked by a scandal because at the highest level they didn't do enough to combat the risk of harassment in the workplace. And you will recall not many years ago, the Clinton administration was also rocked by similar allegations. And I mean, while we all know that these are high risk areas, there isn't enough done in the way of proactivity. I'm now going to call upon George to delve in more deeper into the code of good practice on the prevention and elimination of harassment in the workplace, and to try and iron out whether this is so broad that it basically outlaws almost everything, or where the line is to be drawn between what is acceptable, what is not acceptable, and how do you go about managing this risk. Thank you very much, George. It's over to you.
Thank you very much for that. Thank you, Feroze, and thank you, Makbool. It's absolutely a pleasure to be talking to you all today. I just want to make sure that I can can you see my screen, Feroze?
Yes, I can see it clearly. Thank you, John.
Thank you. So I'm going to do a flyover of the South African history, one can say, our current statutory framework, and then we are going to spend a little bit of time just looking at the code and what our recent code is telling us. And just as a starting point, before we start going through the slides, it is very, very interesting when we look at our own landscape and we consider what Makbool has just shared with us now. So most certainly learnings, but also achievements that I think that we can find. I mean, one of the points that most certainly comes out as a point of discussion every now and then is whether or not we are ahead of the curve from a South African harassment law perspective. Now, I think it's a good starting point to say maybe there's only two things where we can have this discussion. The first is the Springboks, and then secondly, possibly on harassment law. But I'm sure, Makbool, we will have a cup of coffee on that topic. So as we delve into the slides, global perspective, so the first three just identifying the speakers, but the last three bullets I just want to highlight. South Africa submitted its ratification of the ILO Convention 190. Now, the ILO Convention 190 is a convention that should be reasonably well known, but it is the one dealing with elimination of violence and harassment in the workplace. And the point that I want to land is this happened on the 29th of November, 2021, making South Africa the 10th country in the world to submit ratification. Now, a few months later, as you can see from the 29th of November 2021, on the 18th of March 2022, South Africa published its Code of Good Practice on the Prevention and Elimination of Harassment in the Workplace. And the UK submitted its ratification, interestingly enough that these dates are so close together, on the 22nd of March 2022 as the 11th country in the world to ratify the convention. Now, presentation overview, just to give you a feel for what we are going to do in this presentation. Firstly, to look at a South African legislative framework. Secondly, we're going to look at what's new in the 2022 harassment code. We've had codes. We've had a sexual harassment code 1998, 2005 sexual harassment code. And now we have a 2022 harassment code that tackles the broader concept of harassment. And looking at the first few slides that Makbool took us through, we can see that it is very, very aligned to the UK development. We're then going to look at test for harassment. We're going to look at test for sexual harassment. We're going to look at test for racial harassment. So focus on the generic harassment, sexual harassment, racial harassment. And then we're going to do a slide on proactive steps to avoid vicarious liability as it sits in the code, and reactive steps and procedure. Now, to start off with, global and South African legislative framework. So where do we start? We start with the ILO Convention 111. That's the convention dealing with discrimination. The Discrimination Convention is it's often referred to. 151, Occupational Health and Safety Convention. Now, interesting to note that, and something that's very often missed or not mentioned when we deal with our code, but there's most certainly an element and an angle of occupational health and safety within the context of providing a safe working environment, but specifically in the code, references being made to risk assessments. That normally comes from that arena, and you will see in the last slide that I will return to this, and I will again refer to risk assessments. Also, the ILO Convention 190 being elimination of violence and harassment in the world of work. Secondly, the constitutional right to fair labor practices, section 23. So we have a specific section in the Constitution that deals with fair labor practices. We have the Employment Equity Act, known as the EEA, where the sexual harassment codes effectively finds their legislative foundation in. I mentioned the fact that there was a 1998 code, the 2005 code, and then we are currently focusing on the 2022 code. We also have PEPUDA, that's the Promotion of Equality and Prevention of Unfair Discrimination Act, 4 of 2000. That act applicable to areas where the Employment Equity Act is not operational. So more applying to non-employee situations where we have an equality court that effectively deals with those things, but it sits outside of the labor arena, one can say. The Labor Relations Act, obviously, that is the act that deals with dismissals. What is a fair dismissal? And in that regard, it obviously plays. And then we have Occupational Health and Safety Act, which is the OSH Act, the PDA, the Protected Disclosures Act, 26 of 2000, where one of those disclosures effectively makes provision for disclosures under harassment. And then we have the Protection from Harassment Act that takes us to orders which, when one can approach a court, for example, for protection. So the well-known protection orders, which sits in a different sphere and a slightly different angle. So for the moment, we are focusing on the 2022 sexual harassment, or now known as the Harassment Code. And here we go in terms of our slide. So what is new in the 2022 code? The first thing that is new is that there's a holistic view on harassment. It is something that we haven't seen in the past. We have it now. It is a holistic view on harassment, but as you will see the arrow bullet below it, it is limited. It's limited to listed grounds only. And the listed grounds, Makbool referred to it, how it operates in the UK space, in South Africa, and I thought about that it's a good idea to mention them, so that it also speaks to other jurisdictions. We are familiar with them, but ours relates to race, gender, sex, pregnancy, marital status, family responsibility, ethnic or social origin, color, sexual orientation, age, disability, religion, HIV status, conscience, belief, political opinion, culture, language, birth, and we have the add-on or any other arbitrary ground. The code specifically focuses on racial harassment. That's also new. We haven't had this before. And what's quite interesting is in the context of racial harassment, the word unwanted with prescribed informal and informal procedures and formal procedures then also being applicable to racial harassment. So the word unwanted, and what you will note when you read the code is you will note that there's references to unwanted. There's references to unwelcome, especially in the context of sexual harassment, interestingly enough. The word unwelcome often appears, as well as unacceptable conduct. I will take you to that, and it's an interesting dynamic. We think that these words are used interchangeably in the code, but just interesting to note that unwelcome is the word that appears very often associated with sexual harassment. In the last bullet, general harassment, this is also new. The fact that general harassment includes bullying on a listed ground and LGBTQIA+ conduct or related conduct, and unwanted with prescribed informal procedure. So those are two things that we now have informal procedures that also applies to racial harassment as well as bullying on a listed ground. Now we continue with what's new in the 2022 code. Bullet at the top, there's a new concept of knew or should have known that the conduct was unwanted or unwelcome. That is a concept that sat in different legislation. We now see it in the code and obviously brings in an element of objectivity, the test for knew or should have known. And you will see as I move through the slides and get to the slides later on, that it actually talks very much to, in some cases where we have a subjective test, and the objectivity of the test, and also follow as a combination of factors, specifically the words knew or should have known. Then the concept of risk assessments for workplace harassment, mentioned that at the outset. So an interesting dynamic, I will refer to it in the last slide, but it is certainly something that is new. The next round bullet, training, being awareness and general training, and very important as the code lands it, it must be aligned to the code. So strictly speaking, and maybe just make this point, sexual harassment training on its own is not fully aligned with the code. So the training must be aligned with the code, must jointly with trade unions implement awareness training at all levels, and all levels obviously including managers and general employees. And I'm referring this, I'm using the words the jaw-dropping moment and procedural rights. In other words, what's the heart of what that training effectively to all employees speaks to is it speaks to the jaw-dropping moment, i.e. how quickly you can be found wanted on sexual harassment, and then procedural rights. In other words, what rights do I have as an employee when I'm being sexually harassed? Effectively, it's only when those policies and rules are communicated effectively that those procedural rights are alive and assists employers in creating a safe working environment. And everything that we are talking about speaks to the ultimate point of reputation, the point that Makbool landed so eloquently. Reputation is key, and effectively the initiatives that one implements speaks to the bigger picture. So as the code articulates it, I will refer back to the bigger picture from that perspective. The last arrow bullet should include training on sexual harassment, so specifically, and other types of harassment, specifically in orientation, as well as in general training. So the code is reasonably specific when it comes to that, and important to take note of it. Now, what does the code say in relation to what is harassment? I haven't done a full expose in these slides, and the reason for that simply is timing, but I'm going to highlight a few high-level points that makes the point. So definition, harassment is unwanted conduct, and it says whether the harasser knew or ought to have known that the conduct is generally considered as unacceptable, which impairs dignity. You can see similarities as I'm going through these points with the UK law. The next arrow bullet, which creates a hostile or intimidating work environment and relates to one or more grounds in respect of which discrimination is prohibited in terms of section 6.1 of the Employment Equity Act. So all those grounds that I've listed previously, effectively speaking and informing the general term of harassment. Now, also interesting is that the types of harassment on listed grounds includes bullying, intimidation, passive aggressive or covert harassment. So making the point that bullying in fact finds its way into the code, but it finds its way into the code on a listed ground, and bullying finds some kind of definition, being abuse of coercive power. Intimidation finds itself as a description, being intentional behavior that would cause a person of ordinary sensibilities to fear injury or harm. Now, one can once again see the objective wording being used, a person of ordinary sensibilities, also interestingly enough, overlapping with the point that Makbool made. And then passive aggressive or covert harassment may include negative gossip. So quite wide, interesting to appreciate how wide the descriptors are that we find in this, being negative, joking at someone's expense, sarcasm, condescending eye contact, facial expression or gestures, mimicking or ridicule, deliberately causing embarrassment and insecurity, invisible treatment, marginalization, social exclusion, professional isolation, deliberately sabotaging person's dignity, well-being, happiness, success, or career performance. Now, if we look at the next slide, once again, also listing a number of wide-ranging forms of conduct that may constitute harassment, including but not limited to, also interesting that this is not a limitation or a numerous classes, so to speak, but it talks to slandering or maligning or an employee or spreading rumors maliciously, conduct which humiliates, insults, or demeans an employee, sabotaging performance or withholding work-related information, ostracizing, boycotting, or excluding the employee from work or work-related activities, threats, instilling fear, degradation, intolerance of physiological, medical disability or personal circumstances, surveillance without consent with harmful intent, and demotion without justification, abuse or selective use of disciplinary proceedings. Now, those being the wide descriptors, the next few slides, in the next 4 slides, I've done a bit of a comparison between general harassment and sexual harassment as we find it in the code. Now, you will see on the right-hand side, I have shaded the sexual harassment portion to ask the audience really not to focus on the gray sexual harassment portion, but just to make you understand and anticipate what is going to happen 3 slides from this one. So we're going to discuss the black on the left first. We're going to look at harassment as unwanted conduct as it sits in the code. And then we'll do 2 slides to just reflect back on the right-hand side, looking at sexual harassment, but then to reflect back on how general harassment is positioned in the code and how sexual harassment is positioned in the code. So for the moment, the next 2 slides, please just focus on the left-hand side of the slides and not on the gray part on the right-hand side. So what these slides does is it deals with harassment, unwanted conduct, 3 primary issues to evaluate whether you are triggering the knew or should have known that it was unwanted. In other words, a very objective starting point, that the complainant communicated that it was unwanted, pretty much speaks for itself. It was clear, verbal or non-verbal communication. And then making the third point in the third arrow bullet, if there's no communication, the perpetrator knew or should have known that the conduct was unacceptable. So that's standing on its own legs as a separate test. Now you'll see in red me highlighting the objective elements of this test. So the next bullet specifically stating an objective assessment from the perspective of the complainant. And when we look at the perspective of the complainant, there's specific focus on the impact of the conduct on the complainant, but it remains an objective test as it's described in the general harassment clauses. Now the caveat or the defense is that when the perception is not consistent with the views of a reasonable person, that can effectively become a defense to that specific claim. And there's a comparison or a reference to our societal values reflective of a constitutional ethos. In other words, that brings in the objective overlay, one can say, when one is evaluating general harassment. Last bullet, not necessary to establish the intention or the state of mind. I just want to highlight the fact there is some confusion out there. The words not necessary to establish just simply means that it's not a required element to prove, but it remains relevant. And as you can see in the next statement, it may be an aggravating factor relevant to the remedy. So it remains relevant, but it is not a factor that, as a matter of one of the elements that should be established. Now, harassment, it continues, unwanted conduct. The following factors may be relevant: the context of the harassment, the circumstances of the complainant, and the impact on the employee, and the respective positions of the perpetrator and the complainant. Now we're jumping to the right-hand side, looking at sexual harassment. And I want to make the point by just simply pausing for a moment, looking at the 2 points and the parts highlighted in red. So what you will immediately see is what we are quite familiar with. And effectively, if you looked at Makbool's example, you will also draw it from there, even from a UK jurisdictional perspective. That sexual harassment starts off with unwelcome conduct, and it starts off with a subjective view on what is unwelcome and the feelings that is effectively displayed, or the impact plays later on, but unwelcome standing on its own legs, and whether or not something is unwelcome, effectively having a subjective start. Now it refers to verbal or walking away being non-verbal conduct, but that whether or not it's welcome or unwelcome effectively starts with the subjective feelings of the complainant. Sexual nature, similar to what Makbool said, so it must be unwelcome conduct of a sexual nature, and that can be physical, verbal, or non-verbal. The third one, perpetrator knows or ought to know. Now that is new from a sexual harassment perspective, certainly bringing in an objective overlay. And part of that objective overlay, and if you think about what Makbool positioned in relation to training and awareness and the points that he was making, will definitely inform whether or not the perpetrator knows or ought to have known. So very important proactive steps that will effectively speak to the test. The next bullet violates the rights of employees, right to dignity, bodily integrity, safe working environment, etc. Very aligned with the UK, as you would have seen, and then constitutes a barrier to equity, hindrance to engage on an equal basis. And sexual harassment then continues. You will just once again look at the red highlights being subjective, objective, and then impact, subjective, objective, and the last one also being objective. But I'm just taking you through it. The following factors have to be considered: whether harassment is on the grounds of sex, gender, and or sexual orientation. The next bullet, whether the conduct was unwanted or unacceptable, being having a subjective start. And what you will see, what's quite interesting, is that even though the code talks about unwelcome sexual harassment, you here see unwanted being used interchangeably with the word unwelcome or unacceptable. So effectively, you find that in our code, especially on the sexual harassment part, you find unwelcome, but the unwanted word that was under the generic harassment column on the left, you find reference to that under sexual harassment. The next one, the nature and extent of the conduct, that being objectively measured. And the next arrow bullet, the impact of the conduct on the employee. Now, impact starting with subjective and then flowing to objective. The reason why it starts with subjective, and you will see now when we deal with a specific example, a practical example of when sexual harassment happens, that the feelings or the expressions and the impact that the conduct had on the employee is very, very important and very pivotal, and is in fact relied upon by our courts in finding whether or not sexual harassment has in fact occurred. So the next slide is the very well-known case. It is an old case. It's a case going back to 2015 by the Labour Appeal Court by 3 judges. But it is a case that I submit to you is a case that highlights the practical application of the test for sexual harassment in borderline cases, and an interesting question on whether or not this will still be so if one looks at our new code. So as you look at the date, you will see it falls under our previous code, but very, very aligned to what we have currently. Now, these are the facts. Here are the facts of Campbell versus Simmers. Very simply, we have individuals having dinner out in rural Botswana at a game lodge. There's a third person present, Mr. Leroux, who's not at the table, as you can see. And the gentleman makes a suggestion saying, I feel lonely. Do you want to come to my room? Perhaps you want to love it tonight. You can come to my room. And we have a response, no, I have a boyfriend. Now, the reason why this is so apt, in my view, is because it highlights the single incident scenario. So yes, there was a few suggestions if you try to unpack the statement, but it highlights that scenario. And why do we call it, why do I refer to it as a borderline case? One will think, no, but this shouldn't be borderline. The reason why I refer to it as a borderline case is because that's what happened in our Labour Court. The Labour Court initially found that there was no sexual harassment in this specific event. Now, I'll deal with that first bullet just now. But effectively, one of our most respected judges, who has unfortunately passed, Judge Steenkamp, found that he was merely trying his luck. It was a borderline case. He was merely trying his luck. This did not constitute sexual harassment, was the finding by Judge Steenkamp. This matter went on appeal to the Labour Appeal Court in front of 3 judges, and the Labour Appeal Court found the opposite. The Labour Appeal Court found that the Labour Court erred. The Labour Appeal Court found, by looking at how the victim felt, confirmed that this was indeed sexual harassment. And that's why, in my view, it's quite important to just highlight the following 3 paragraphs coming out of that judgment that basically makes the point. Now, the first bullet, while the Labour Court found that the advances was crude and inappropriate, it erred in finding that the advances made constituted inappropriate sexual attention, but not harassment, that they were not serious, and that they did not impair the dignity of Ms. Makidis. No disparity of power, and the 2 were unlikely to work together. So what the Labour Appeal Court says, these were the mistakes made by the Labour Court. Next paragraph, to the contrary. This is the Labour Appeal Court speaking. The unwelcome and inappropriate advances were directed by Mr. Simmers at a young woman. You see context, close to 25 years his junior, and whose employment had placed her alone in his company in rural Botswana. And then the next paragraph, and you'll please focus on the underlined words, effectively talking to the feelings of Ms. Makidis. Ms. Makidis' dignity was impaired by the insecurity caused to her by the unwelcome advances, by her clearly expressed feelings of insult. So that's what became clear. As much was apparent from her evidence that she was insulted, felt incredibly nervous, given the proximity of the sleeping arrangements at the lodge, and that she programmed Mr. Leroux's number. Now, Mr. Leroux was the gentleman who was no longer sitting at the table, onto her phone just in case anything happened. So looking at not only her feelings, but also to the fact that she was programming Mr. Leroux's number onto her phone. So very interesting to see and to share with you that the subjective views and feelings of the complainant effectively being highlighted in coming to the conclusion that there was sexual harassment. Now that, of course, is to be compared with, and I'm now going back to the slides where I started before I dealt with the Simmers case. And this time, racial harassment. So this just to be compared with racial harassment, what I've done is on the left, you will see a column in the next 2 slides that has been grayed out. So please don't look at that. That is the slides that we looked at earlier in effectively talking to unwanted conduct and harassment in general. But these 2 slides are focusing on racial harassment. So effectively the third leg, one can say, that is specifically highlighted as a specific type of harassment that is dealt with in our code. Now, and interestingly enough, given our history, I think totally apt and appropriate that we have specific focus on racial harassment. Racial harassment, unwanted conduct, and this is what the code says about it. I'm just looking at the black slide on the right-hand side of the slide that I'm looking at. Factors to be considered in racial harassment: whether conduct complained of is abusive and impairs dignity, whether the conduct is directed at a particular employee or employees, the extent and degree of abuse or impairment to dignity, and then the impact of the conduct. So once again, the word impact being reflected specifically in racial harassment. And I've highlighted in this slide, which is the second slide dealing with racial harassment, the objective layers that comes in considering racial harassment. The test includes racial harassment must be assessed objectively, that is specifically in the code, reasonable person in keeping with constitutional values. So it also gets color by means of that descriptor. What that means, it refers to a reasonable person in keeping with our constitutional values. So you can see our historic context also following what we are doing with racial harassment. The next arrow bullet, established on a balance of probabilities. Now we know balance of probabilities gives us an objective measurement. That conduct related to race, ethnic, or social origin. The next one, assumed to be unwanted conduct if it's explicitly racial. So also something that rubs shoulders, I can say, with a point that Makbool made. The next arrow bullet, whether the conduct amounts to harassment depends on, and then we have 2 points following that, whether the conduct was persistent or harmful, demeaning, impairing dignity, humiliating, or creating a hostile environment. I'm going to go through the next 2 slides pretty swiftly. I've got 2 slides left, but I don't want to overrun my time. So here's the proactive steps as it sits in the code. Firstly, the code, it is a guideline, but it provides that having a harassment policy and effectively communicating the policy, training and evaluation is required as part of the employer's proactive steps to avoid liability in terms of Section 60 of the Employment Equity Act. That's our liability clause. The next arrow bullet, harassment policy should at least include the following. So there's pointers that must be in your policy. Harassment will not be tolerated. Harassment on a prohibited ground is a form of discrimination. Next one, complainants have the right to follow formal or informal procedures. Procedures must be outlined in your policy, and the availability of counseling, treatment, care, and support programs. Now, those are proactive steps. And now this last slide is just a slide that gives a reactive steps and harassment procedure as the code articulates it. Now, it's in my view, a slide that nicely captures different angles of employment law coming together. Informal mediation coming together on the left-hand side, with what you find in the middle, the formal part of employment law being formal investigations, disciplinary hearings, and so on. And on the right-hand side, you will see on the side an occupational health and safety angle being risk assessments. You'll see there in brackets declarations. That is what a number of our clients are using as a form of risk assessments. So just very quickly from the top, harassment complaints. It calls on consultation is required by designated specialist outside of management. Now that designated specialist speaks to the champion that Makbool also referred to. So very similar in our code, i.e. a reference to a specialist that understands harassment, that deals with it. Then providing the policy advice on informal and formal processes, assistance, counseling, confidentiality, even a reference to advice on criminal charges and disciplinary processes. And then complainant decides if the matter goes informal or formal, and under informal, you will see there a reference to mediation. So in other words, disclosures, what disclosures can be made, is it confidential or can the names be disclosed? Mediation resolved, that's the end of it, leading to a confidential record. Unresolved, it goes formal. And then under the formal process, you see formal investigation, finding of prima facie merit or not. And then if there's prima facie merit, you find that there's disciplinary action. And then after that, our code allows for the complainant to go to the CCMA. So it can be escalated outside of the employment sphere. Thank you very much, everybody. That is the end of my slide presentation. And I'm glad to hand back to Feroze.
Thank you very much, George, for that very helpful and detailed analysis of the code, especially for the Simmons example and also the practical advice. And George's slides will be available to participants to be shared after the seminar along with Makbool. We don't have much time, so I'm going to give it over to Nic Preston. He's sitting in Canada. Nic, you've got 15 minutes to do your presentation and give us, what the context and what the law says over, on that part of the world. Thank you.
Thanks very much, Feroze. Good afternoon, everyone, or afternoon, as they say here in Canada. For those of you who do know me, I see there's some familiar names on the line here. I practice in South Africa, and I practice in Canada, have been for the last 3 years. So I was quite sort of pleased when Claire asked me to speak, because I thought that I could maybe share some of the perspectives, having practiced in both jurisdictions, just in terms of giving a comparative analysis between harassment, how it operates in South Africa, and then how it operates in Canada as well. I think the one thing to maybe just understand that there's a slightly different governmental regime in Canada. We've got a federal and provincial system. So there's provincial laws and federal laws as well that apply in different spheres of the employment world. So federally would be things like banks, postal services, logistics, cross-border travel, any sort of business that operates in that space would be federally regulated and would have its own sort of rules and laws and so forth. And in relation to the issue of harassment, particularly, that's all regulated under a piece of legislation called the Canada Labour Code. And I do have some slides just to share with you. They're very brief. I'll pull them up just so that you can follow along with me. So there's really the two systems, provincially and federally. Under the federal system, we've got the Canada Labour Code. Provincially, we've got the Occupational Health and Safety Act, very similar to South Africa, and then also the Human Rights Code, which is where you're finding the sort of protected or listed grounds that George has gone through this morning. And pretty much, I would say, aligns with what we have in Canada compared back to the code. I think the one thing that I have picked up, which was an interesting observation, is that there's certainly a stronger emphasis in the new code that's been published in South Africa to the issue of racial discrimination. It is obviously mentioned in Canadian jurisdiction and legislation as well, but that seems to be where I would say South Africa, and at least through the ILO Convention, is moving leaps and bounds ahead. The issue of race is mentioned, but there's no specific analysis or specific wording as we're seeing in the current code in South Africa. So I thought that was an important issue, and maybe just a feather in the cap to point out to everyone back in South Africa that I think the legislation is moving in the right direction there. The other thing that I kind of picked up, which I thought was interesting, just working through the code, is around the enforcement. And here again, another comparative analysis between the two. So in Canada, if there is an harassment complaint, and I would say just in the last 3 years, they're pretty frequent in the workplace. They're raised, often I would say by employees, both in the unionized and non-union sector. But the moment that there's a harassment complaint, there is this obligation to go ahead and to perform an investigation. That can be done internally or externally. And I would say in the majority of cases across, at least in Ontario, the province that I practice in, there's sort of institutions like Access HR who specifically run these harassment type investigations independently, much in the same way that you'd have an independent chairperson in South Africa for disciplinary hearings and so forth. And they would perform this independent investigation, provide a report, and hand that back to the company to be dealt with. The one thing that's interesting on that particular issue is that if the employee is not satisfied with the outcome of the investigation, they can go back to the Ministry of Labour, who can require that a further investigation be done, or if no investigation is done, they can require that one be done and put the employer on terms. And obviously, we'll have a look at some of the relief and so forth that can be granted in those cases. But the one thing that sort of impressed upon me, just reading through the code and comparing it to Canada, is that I feel that there's still a much quicker route to a resolution on the Canadian side. So although the code's moving in the right direction, and there's certainly leaps and bounds, I would say, ahead of where Canada is in some respects, the enforcement side still seems to be lacking. It seems that the enforcement is still through the CCMA by way of conciliation, and then ultimately through adjudication at the Labour Court, which, as we all know, takes some time. Through the Ministry of Labour, you can have a ministry inspector at your office within a day, and an order that swiftly follows thereafter. So I find that getting the wheels moving is a lot quicker from the Canadian perspective, and that's maybe something to just consider when preparing your policies, I suppose. This is obviously, it's a code of good practice, and it provides helpful guidelines. But as each and every one of you work together with Access to prepare your respective policies, there may be some thoughts around, making sure that there's some swift action to be taken around dealing with harassment and potentially discrimination in the workplace as well. One other issue in Canada, which I didn't quite see in the South African code, was this ongoing obligation to, on an annual basis, update your harassment policy, to revisit training frequently. And I mean, I think that may be the intention, certainly in the South African code. But again, it may be a suggestion just when preparing your respective policies, just in terms of setting some sort of review period. When is it going to be reviewed? When are you going to relook at things? And that may all tie into some of the sentiments that were shared this morning, in terms of showing, like Makbool had shared, what onus has the employer met in order to try and take every reasonable step to avoid harassment in the workplace and avoid issues of vicarious liability. So if your training's on par and it's happening frequently, if the policy is being reviewed, if there's activity, at least in the early stages of a harassment complaint or investigation, rather than waiting for someone to go all the way through the CCMA and ultimately the Labour Court if there is an issue, those may all be positive signs, I would say, in terms of dealing with this adequately in the workplace. One other observation that I picked up, which I thought was welcome, was in paragraph 2.2 of the South African Code, where, and it was something that I had in mind when I first read it, where it kind of extends to suppliers, customers, and others having dealings with business. Now, we don't have similar wording, at least in our harassment legislation in Canada, but I do think that that's becoming an increasing issue. George shared the Steenkamp decision a little bit earlier, which I thought was perfectly timed for this sort of topic. But we do see harassment happen at work functions outside with other suppliers, third parties, where there's not necessarily a direct employment relationship. And at least in Canada, there's an overarching obligation to protect your employees from harassment, whether internally or externally. And I think in substance, the code is really suggesting and codifying, what we've seen in Campbell and Simmers and further decisions in South Africa, making sure that it operates sort of on a more global scale. If it's an employee and they've been harassed, there's probably an obligation on the employer to take some form of action, I would say. Just in terms of some future thoughts that I thought were helpful, it was welcoming as well to see in the South African code that it speaks to the code applying virtually. As we know, with COVID, most people have sort of moved into the remote work environment. And our firm's been instrumental here, at least in Canada. We've had our first moot court that was done through the University of Ottawa in the metaverse, which is kind of the next step after remote work and Zoom and Teams and all of those sorts of things, where people sort of have headsets and live in a virtual world. And people are having virtual meetings and virtual team buildings, and we're having virtual hearings where you're in a courtroom, but you're actually sitting at home in your office or your lounge, whatever it is, and you can move around, you can show pieces of paper and so forth. But the big question is, I mean, the more and more the world of work and the reality of life moves into these virtual spheres, such as the metaverse or even online through Zoom and otherwise, harassment lives there too, as does discrimination. So that's maybe another thought just to including any policies, so that it's kind of future-proof, or at least start thinking about these things. Because as we've seen, global pandemics happen, we have super flus, and all of a sudden there's a need to immediately pivot and make sure that our legislation's up to date, which often it's not, and that our policies are up to date and future-proofed in some regard. Then in relation to the Canadian Occupational Health and Safety Act, I did mention obviously that there's this reference to ancestry, color, race in particular, and citizenship, but no clear focus. So I would say Canada's a little bit behind there. I did have a look at the ILO Convention 190, and Canada hasn't yet ratified or signed on to that ILO Convention. So South Africa's leading the way, so congratulations on that. And then a couple of other similarities as well, I would say, and maybe another feather in the cap here, that there's just a global alignment on the issue of dealing with harassment and discrimination in the workplace, where again, singular acts both in Canada and in South Africa can constitute acts of harassment. We've had legislation and jurisprudence here, at least for many years, around bullying in the workplace, which is very prevalent, I would say, and there's still a lot of case law happening. And then there's another reference that they have in Canada, which I haven't picked up in South Africa or in the code, which is the creation of a poisoned work environment. And that often leads to claims of constructive dismissal. Now, I think it is there in the code, just maybe in a different form. George had mentioned earlier the passive aggressive or covert harassment. And I think that would probably be the equivalent of the poisoned work environment. So just to point those issues out for you. In terms of the test between South Africa and Canada, I think we're largely aligned. Primarily the test, at least in Ontario, is more focused on an objective test, but we do see subjective elements coming in from time to time. So complete alignment there. And it seems based on Makbool's presentation that we're seeing something similar in the UK. So there's almost this global development of jurisprudence around harassment and discrimination in the workplace. And we're definitely seeing some synergies between those pieces of legislation. The procedure I did touch on briefly, just around the workplace investigation. The one thing that's interesting here is if you have a look at the Occupational Health and Safety Act as it applies in Ontario in Canada, it says that at the end of the investigation, both the complainant and I suppose the victim, and I know that there's some analogous words that can be used there, but the relevant role players, I suppose, in a complaint around harassment, all that they need to be informed of is the outcome of the investigation. So very often, unless there's future litigation, they don't ever get the full investigative report. They only get a summary to say investigation was concluded, it ran over X days, we saw 15 witnesses, and this is really the outcome of the investigation. There was a finding or there was no finding, and this is what the company's action is going to be or not. They never actually get the insight or the details around that, unless obviously it goes to litigation and then there's orders to produce the report, which can at times happen. But I think it touches on some issues that were mentioned earlier today as well, just the sensitivities that often exist around these kinds of investigations and how one protects individuals and role players. And I think maybe built into the local Occupational Health and Safety Act here in Canada is that's really the purpose of only giving them the outcome, at least at the early stages, is just to protect the identity of individuals. And I recently had a case, and I may be just sharing this with you just to sensitize one to, I suppose, some of the other maybe not so obvious issues that arise from time to time in the harassment space, where an individual was called as a witness, an employee was called as a witness to give evidence in a harassment investigation that took place on an independent basis. And there was then a finding of harassment. The individual was dealt with, their employment was not terminated. And in the weeks that followed, the person against whom the harassment complaint was made walked up to this particular witness and mentioned to her fairly loudly, sort of in a public setting, that as you can note, I'm not raising my voice, I'm not speaking loudly, I don't have an aggressive tone, and I just want you to take note of that. And he made it pretty clear and was fairly forceful in the manner in which that was sort of communicated to this witness who had earlier testified, which in itself is potentially a form of harassment. it's a form of reprisal for that employee having participated in an earlier harassment investigation. So I think it's important that even when harassment is dealt with, that often there's sort of offshoots where harassment complaints may still, there may still be fertile ground for further harassment. And the issue of reprisal, I would say, is certainly one that should be written into any policy, so that one sort of potential harassers are made aware of their obligations and bring their conduct into check, but also that any victims of future harassment or any sort of subsequent harassment realize that they're protected and that there may be a basis to bring those issues forward. In terms of the Ministry of Labour, I've mentioned there that they have a much more robust and expeditious approach to harassment in the workplace. There's no litigation that's required in order to make a harassment complaint here. Certainly it can be challenged later down the line at the Human Rights Tribunal of Ontario, or at least federally in their relevant forum. But it is easier to get the wheels of motion moving, I would say, in Canada, if the employer is not prepared to do anything, or if the employer sits on their hands. It's a quick call. The next day you've got an inspector on the ground and you've got an order to run an investigation. There's usually a time period too. And if that time period's missed, there's relief and remedies and orders for damages and fines that can be imposed as well. Whereas if an employer sits on their hands in South Africa, it would seem that one of the only approaches may be to sort of take the litigious route, which is often expensive, and maybe dissuading to any employee to follow that ultimately. In terms of just where harassment complaints often go in Canada, I've said that there's Ministry of Labour fines. They're fairly hefty fines, certainly in rands terms. It's nothing to see a $50,000 or $100,000 fine being given to an employer for failing to, one, have a harassment policy to start with, a lack of training, a proper health and safety committee, if one's required, and that's obviously means tested in the Act, whether you should or shouldn't have one, the failure to conduct an investigation in a timely manner, or the failure to even conduct a proper investigation. So again, I suppose we're certainly seeing a shift, at least in Canada, and it's almost a given that if there's a harassment complaint, it goes to an independent party for an independent investigation, and there's then a report. We do see often litigation with damages, vicarious liability. There's WSIB claims. We've had issues where employees say that they've suffered mental anguish or suffering or pain, whatever it may be, as a result of harassment. So that can be claimed through the WSIB, or in South Africa, the COIDA equivalent, claims for constructive dismissal. And then I've mentioned, obviously, just the efficiencies of dealing with those sorts of disputes. So wanted to just give you a quick rundown of the South African versus Canadian comparators, just some of my experiences and observations, and hopefully that was helpful. And just wanted to thank everyone for being on the line, and thank you to Access HR for the opportunity this morning, or this afternoon, should I say.
Thank you very much, Nick. We really appreciate your attendance and sacrificing your early morning for us. We've got till about past to take some questions. I don't know if there's a screen where you can put your questions, but I think that there's two important things that we can take away from the discussions of all three of our panelists. I mean, and the one is, you have these straightforward cases of racism and sexual harassment, which are not complicated. But then you have these difficult cases, borderline cases. And it seems to me that the international move is to really take a victim-centered approach to the question. So rather than looking at the intentions of the aggressor or the accused, one looks at it from the perspective of what impact a particular statement or cause of conduct had on the complainant, in order to judge whether a statement may be racist or amount to sexual harassment, for example. And obviously there one has to look at firstly the subjective state of mind of the complainant, but then also assess it for reasonableness. But I think that is very important takeaway point for me, is that when you have these difficult cases, we often try to look at it like criminal matters and ask, is the accused guilty of something, and look at the accused mens rea or intent. And the focus seems to be shifting away from that, but to rather looking at the impact on the complainant, which is a very important move, and I think that's internationally accepted. So there's a very victim-orientated analysis here in deciding whether something amounts to sexual harassment or bullying or whatever it is. I think the second point is the importance that I think each one of our three speakers have highlighted, is that the need for employers to be proactive. And while I think most employers should have codes, sexual harassment and racism codes, and if you don't, obviously that needs to be done urgently because it's almost seen as a mandatory requirement now. But apart from those codes which allow for informal and formal resolution of these types of disputes at the election of the complainant generally, but management has to have a supervisory role over that and may still decide to take action if the complainant doesn't. But there's more proactive steps that one has to look at when you're looking at some of the things that Makbool has highlighted and George, also Nic is there, is the importance of training, both entry-level training and regular follow-up training, publishing statistics in your workplace, having an employee support program, ensuring speedy outcomes, and that's where I think we get lost in our country, where we still have this criminal trial, long investigation, long processes in the workplace, could take months. And I think that in one example where the employer gives a 1 month commitment to resolve issues like this is a very, very important step in this process. And then having advocacy champions who are independent in the workplace, and also having anonymous hotlines. So those are some of the more, I think, the additional practical steps that employers can take over and apart from just having codes and having your normal disciplinary processes in place in order to ensure that you don't land on the wrong side of the law here, especially in this very, very high risk environment. So I think that's what I'll take away. There's another interesting area which we haven't really looked at, is the relationship between vicarious liability and the Employment Equity Act, and the extent to which in the common law an employer can get away from liability if it has taken reasonable steps. Because vicarious liability doesn't really work that way. And we have two judgments of the Constitutional Court, certainly in the public space, where the police was held vicariously liable when police officers who were off duty raped members of the public. So these are off-duty policemen, but they used their police credentials in a manner of speaking, even though they were off-duty, to lure their victims and to actually commit these heinous acts. And the police in both cases was held to be vicariously liable. And I mean, so there you have an area which I think is going to develop more, and the extent to which private employers are going to be held vicariously liable is a matter for debate and future jurisprudence. But there it really becomes important, as Nic said, to try and avoid liability in that space, to have all of these proactive policies so that you can convincingly argue to a court that if something happens, it isn't in the cause and scope of the employee's employment. And that I think is a future area where the law is going to develop. I think I'm not sure if there's questions, Claire. I don't know how to check these questions. There's no. Is there
Thanks,
any way?
Feroze. No questions, just some nice comments. Thank you. But if you think of any further questions once I have sent you the presentations a little bit later, you're welcome to respond to me, and I'll pose them to the presenters on your behalf.
Okay, so thanks you. If there's no questions, I want to really thank our three speakers again for their very illuminating discussion and for educating us and conscientizing us in this very high risk area. And I want to thank Access for organizing this event. And
Sorry
obviously,
to interrupt you, Feroze. I'm sorry
no
to interrupt. We do have a question.
Okay.
Can I read it out loud
Yes,
to
yes.
you, or do you want to read it? What is the presenter's views on the rights of a witness in a harassment case, and particularly in an environment where there is real risk to the witness for reprisal, given the level of violence against women, particular in SA?
Okay, I think it's a very good question. I mean, I think Makbool, in your area, and Nick, I don't know if you're going to share, or George, if you want to say anything about this. Or Salul Makbool? You're on mute, Makbool.
Yeah, no, sorry, Feroze. It's similar to what you've said, that there are specific circumstances. If there are extenuating reasons, the courts do accept anonymized evidence. If any witnesses are subjected to harassment themselves, then they have a remedy. So there are victimization provisions in the Equality Act which they can exercise. So as you say, protection for witnesses is available and provided. So it's a similar setup. And I think the responsibility is on employers to think about these things in advance and give those assurances to witnesses and manage the process in a way that they will get the right result.
Yeah, thank you. And I think that's something that maybe you want to add in your codes, that type of assurance to victims that they're going to be treated confidential, or their confidences are not going to be breached. And if they require whatever protection and assistance, that will be made available by employers in the workplace environment. And that's a very important thing. Nick, you want to say something?
Feroze, I just wanted to quickly add, I mean, there is a body of law, certainly in South Africa, that allows for evidence in camera, like you had mentioned. You've probably had a number of these yourself, but I mean, certainly we've had disciplinary hearings when I was back in South Africa that were done in camera. And we've also brought those applications before the CCMA. So where there's future litigation sort of moving through the dispute resolution process or adjudication process to allow for witnesses to testify in camera and to even be anonymized. And we've used sort of voice changing software and witness 1, witness 2, witness 3 sort of thing to sort of protect the identity of witnesses or employees against the issue of reprisal, right? And against identity concerns that they may have in coming forward. So I think it's a good point to bear in mind, but just so that everyone knows that there is a body of law that permits that, if ever there's a need.
Thank you. Thanks for that, Nick.
Okay, before we go,
yes, sure. Carry on.
I mean, Nick obviously has experience of South Africa, but I think one is perplexed as to why employers haven't moved away from this sort of criminal type approach for investigations. And is there any, I mean, maybe it's a subject for another day, and we're obviously very limited in time, but is there any reason why there's been a lack of momentum in trying to create more efficient ways of dealing with these matters? Because I can imagine, as you say, if it takes months, that just creates and even exacerbates an existing difficult situation. And I would have thought that there has to be some attempt made by businesses to create more efficient processes.
Yeah, I think a lot of it, Makbool, I mean, maybe George can come in and answer that. George?
Sure,
what
thanks for that, Makbool.
the problem?
No, so I do think our employment law needs to move to that development to bring resolutions quicker than what we are doing. I think the concern is validly raised that our current mechanisms, disciplinary hearings and so on, effectively brings a slowdown to the process and effectively dealing with it. Now, that last slide of mine, the intervention of mediation, for example, I think can be very, very successfully implemented in dealing with these disputes. So that is certainly one of the items that is in play when you look at the informal procedure that the complainant can elect to deploy. So within that informal procedure, our advice lands both as an internal mediation option as well as an external mediation option. We've been involved, Feroze and myself, we've been involved in a number of cases where that internal or external mediation would have probably brought a better result than lengthy litigation. It is so, one of the reasons complainant elected is one of the reasons that effectively determines your outcome. And obviously also the fact that it's a matter of great sensitivity in terms of how it is treated. Makbool, what I can share with you is we are certainly moving in South Africa to a more informal disciplinary process as opposed to formal disciplinary processes that's run like criminal courts. Now, it is so that certain practitioners obviously leans towards the one or the other side, but the informal disciplinary process is effectively sanctioned by our Labour Relations Act. So we are of the view that as we get closer to that, we should be getting answers that are more speedily and brings a quicker resolve to these sensitive matters.
Thanks, George. I mean, I share those sentiments. I just want to add one of the big problems is that you have companies that have entrenched their criminal style disciplinary codes into contracts of employment and collective agreements. So now you need to get out of those things, and you can only do so without consent, or you need to amend those terms and conditions unilaterally, and there's a process that you need to follow. And I think that's part of the major problem. There's this historic problem where these criminal style codes have been entrenched contractually and people can't get out of it. So thank you very much.
Feroze, I just want to say there are 2 more questions. So I don't know if the speakers are happy to stay on, or if you'd rather that I just took those offline.
Well, I see the very respected Professor Stefan van Eck on the line, so most certainly
Yes.
I'm here.
And then for Kile, he's also asked a question. Stefan, do you want to come online and ask your question first, and then we'll move to Fakile?
Yes, thank you. And first of all, thank you to each one of the speakers. Absolute excellent presentations. I've got a question about the informal mediations at the workplace. George also just alluded to it right now. How valid would such an agreement be where, just as an example, one of the senior executives conclude an agreement to pay a sum of money to the employee for their silence and to withdraw all complaints and even possibly to be moved to another division. And then 2-3 years later, such an employee says, but I'm no longer happy with that agreement. How valid would such agreements be? Could we possibly start off with George and then get some insights from the other countries as well? Thank you.
Thank you, Professor, and thank you for that. So it is the consequence of allowing for a complainant to choose a procedure that you move into an informal process, and that informal process has got the desire and the purpose to resolve the complaint. So it's within that context and within that framework that you sometimes have agreements being struck. And obviously the terminology and what the agreement actually entails will determine whether or not the complaint has been resolved, and that will have an impact on the vicarious liability of the employer at a later stage. In other words, and it's interesting, but I've been involved in a similar matter where there was a resolve, and then 3 years later there was an allegation that the complaint was actually never resolved. So that's why in that last slide of ours, the recommendation was that it should be reduced to writing. The suggestion is that it should involve all 3 parties, being the company, the complainant, as well as the alleged perpetrator, and that the outcome did effectively resolve the complaint, so that these type of things are not left hanging, and that prevents a 3-year later type arrangement coming up. So most certainly that's not a type of a let's agree to sweep it under the carpet type agreement by the individual. It is effectively following the informal process. And then we rush to remind ourselves to the fact that the employer is obliged to keep an oversight role in terms of what employees are being exposed to and whether or not they are indeed providing a safe working environment. And in fact, the employer, as the code says, has the right, and in our submission, sometimes the obligation, to decide to go formal, even if the complainant have decided that the matter has been resolved. Now, that obviously brings about its own complications. For example, an unwilling complainant that is now in a formal process. But from a code perspective, the employer certainly not only has that right to effectively decide to go formal, in other words, when there's untoward conduct, to try and cover it up, if you like. And so not only the right, but also the obligation, in our view, to do that. So in other words, every case to be evaluated on its own merits, and a very careful analysis should be made before that decision is taken. That will be my view, Professor.
Makbool, you want to add anything to that?
No, I mean, as one would expect, it's an excellent question from a leading academic in South Africa. It presents lots of dilemmas, and the role of lawyers, interestingly, is also highlighted, and the regulatory body in the UK has given specific guidance to lawyers about entering into such agreements. We saw it in the Harvey Weinstein case, where non-disclosure agreements were used to effectively silence the complainant and advisors for the complainant. And it throws up lots of ethical dilemmas. Most employers now, you're not allowed to, you have to be very careful in putting in non-disclosure agreements and going down the informal route for the very reasons that the professor highlights. So there's a parliamentary committee that's reported on this, and lawyers have been criticized for going down this road. And it's very, the employers reserve the right to allow mediation only in those cases where it is appropriate. Otherwise, it should always go down the formal route. And any, as I say, lawyers involved also have to be very careful, because the lawyer from a leading law firm in the UK is involved in one of the Harvey Weinstein cases, was subjected to a disciplinary process because the allegation was that, you know, his involvement was complicit. So it's a very difficult issue. And I think informal process and mediation and non-disclosure clauses in such mediated resolutions need to be used sparingly in limited cases, for the very reasons that the learned professor, I think, implies.
I think one last question for us. In a case where an employee makes racial comments on social media, could they be disciplined on that regard? And if the employer doesn't, would they be held liable?
George, you want to take that?
Yeah, sure. Thank you. So I think the short answer is yes. So media platform specifically referenced. So the answer is yes. If it is an employee and it falls within that category, it effectively triggers the code. So the code highlights the obligations that's on the employer, and the employer potentially becoming vicariously liable in terms of Section 60 of the Employment Equity Act if they don't take all. So our legislation refers to all reasonable, practicable steps, which is slightly different from the UK angle, but effectively the employer can come into play if they don't act in accordance with how the code guides the steps that they need to take.
Thanks, George. And Nick, do you want to have any final say here?
Thanks, Feroze. I just had two brief comments just to Professor Van Eck's question. Certainly in Canada, there's also a highlighting of the lawyer's role to play if there is a lawyer that's involved. It can be considered a sharp practice if an agreement's entered into, especially in circumstances where one party is legally represented and the other isn't. So very often we're seeing clauses being included to say that in considering this agreement or this mediated outcome, you've had the ability to go and secure independent legal advice, and you either have or you've disposed of the need to do so, being fully aware of the ramifications around that. We also find, again, and maybe depending on the nature of the issue, and I would say that harassment is always a sensitive one, but in settlement agreements, typically here, we find standard language around the recovery. If there's any amount of money that's paid, if there's a later breach or distancing from that agreement, as has been suggested, there may be a basis to have to repay the money or recover that money, and that's often put into settlement agreements. In the harassment context, I would say that that's cold comfort, though, to any employer. These agreements are only sort of as good as what they complied with. And the reputational damages, if an employee does turn around 3 years later to say the behavior has really continued, things haven't improved, and I'm not going to sort of be a whistleblower, so to speak, or I'm gonna sing from the treetops about this particular issue. Your agreement's only going to go so far. The reputational damages are there, and yes, an employer may have further claims, but I think it's a sensitivity, an important one to bear in mind when dealing with harassment complaints and keeping the dealings respectful all the way through. There is a duty of good faith here, and I know that it's implied in South African contracts too, but it's an express duty here when dealing with employees. It can trigger a separate claim for damages if there's been any bad faith shown on the part of the employer, either now or sometime later in the employment relationship. So I think it was a great question to be raised, and maybe just bringing home the sensitivity aspect when dealing with these issues.
I think it's a superb question. I think the Jeffrey Epstein matter, where the state actually were complicit in having a non-disclosure clause and a plea agreement of that kind. And it really blew up many years later, and the court actually set that aside. So, it's a very, very good question. And I think Makbool's advice and George and everyone's advice is sound, that you reserve it for, you don't look to reserve it for serious cases. You reserve it for the less serious cases, perhaps, and make sure that it's all independent, fully disclosed, all above board. And if you need to have, advice of your professional bodies to play a role in that, then I think that as lawyers, we have that refuge, and we should take that also. So it's been a really illuminating, excellent discussion. I certainly learned a lot, and I'm sure everybody's benefited. And if you want to contact any of our speakers, please just get hold of Claire, and she'll put you in touch with them. Thank you very much, everybody. I think, Claire, we can sign off.
Thanks, everybody, for staying on, and sorry for going over time, but we appreciate your support. Have a good evening.
Thank you. Thank you, everybody.
Thank you. Bye.